good morning. I am Denise Pisa with Causa. I'm the Oregon Ready Coalition Manager. Welcome to the update on the new public charge rule webinar brought to you by Causa, the Oregon Law Center, the Oregon Latino Health Coalition, and Oregon Health Authority's Community Partner Outreach Program. I'd like to review a few quick housekeeping items. Like the previous webinar, this webinar is being recorded, and because of this, all attendees are on mute. We will have a live Q&A session at the end of the webinar. The questions will be facilitated by Josie from OHA, so please type your questions in as we go, and with that, we'll get started. Like I mentioned before, I'm Denise Pisa with Causa, and I will be the moderator and presenter for today's webinar, along with Josie Silverman Mendez from OHA, and our other presenter today will be Beth Englander from Oregon Law Center. And we will be answering questions that came up during the webinar previously, and questions that come up during the webinar today. This webinar was also made possible by the support of our community partners, including Oregon Health Latino Coalition. So, what will we be covering today? Today's webinar will be focusing on providing an update on the now blocked federal public charge rule, including why the new rule was blocked and how long the block will last. We will provide Oregon-specific and national resources for you to access to stay updated as things unfold, and we'll address some of the commonly asked questions we have been hearing from the community. Also, we will be facilitating a live Q&A at the end of the webinar, as we mentioned, so please remember to type your questions into the webinar platform. Please note that for an in-depth overview of the public charge rule, and the now pending changes to the federal rule, including who is exempt and what public benefits count as public charge, we encourage you to reference the webinar on the public charge for the Oregon service providers. It was hosted on October 8th, and you can access this webinar in English and Spanish at OregonImmigrationSource.org. As we can see on this slide, we have included Oregon-specific and national resources that we hope you will access to stay up to date on public charge. These include the Oregon Law Center Public Benefits Hotline, which is 1-800-520-5292, Oregon Immigration Resource, which includes the webinar from October 8th, the recording and the PowerPoint presentation, Oregon Public Charge Fact Sheet, the State of Oregon's frequently asked questions on public charge and ongoing updates from OHA. We have resources for Oregon immigration attorneys and the National Protecting Immigrant Families campaign.
Good morning. Thank you, Denise. My name is Beth Englander. I'm an attorney with the Oregon Law Center. Oregon Law Center is a nonprofit law firm, and we do civil legal cases for people who are low income. Our services are free for low income Oregonians, and our services are also confidential. We have offices throughout the state of Oregon. The map that you're looking at shows both Oregon Law Center and legal aid offices throughout the state. We work in conjunction with legal aid. We represent many low-income immigrants on all types of civil legal cases, so please feel free to refer any of the types of cases listed above to your local legal aid or Oregon Law Center office. If the county that you live in doesn't have a star in it on this map, that county is still assigned to one of the local legal aid or Oregon Law Center offices, so just call the closest office to you and you'll be directed to the right place. I do want to note that Oregon Law Center and Legal Aid run a statewide public benefits telephone hotline. That number is above, and Denise just mentioned it. It is generally open Monday through Thursday, and it's a good resource for legal questions about public benefits, including about public charge. The hotline is accessible to people who don't speak English, and soon, hopefully within the next week or two, we will begin to have some very limited evening hours for people to call specifically about public charge. I would recommend that people call the 1-800 number and listen to the recording in order to find out exactly what evening hours will be for a given week. Next slide, please. So public charge is not a new rule, and it is not a new concept. We went through the history of the public charge rule and lots of the basic concepts of the old and the new public charge rule in the October 8th webinar, as Denise mentioned earlier. You can still view those slides and listen to the recording if you need basic information about what is public charge, when does it apply, who does it apply to, etc. This webinar today is an update to the October 8th basics webinar. So we're not going to go over all the same things that we talked about on October 8th. This is an update, and the update is important because important changes have happened since October 8th to the new public charge rule. The new, harsher public charge rule was supposed to go into effect on October 15th of this year. That new, harsher public charge rule was going to expand the definition of public charge, of who is a public charge, expand the list of public benefits that count in the public charge test, and expand the public charge test itself to make it harder for people to pass if they aren't already wealthy. However, before October 15th, the day it was supposed to go into effect, multiple federal judges blocked the rule from going into effect because of many lawsuits that were filed against the new rule. So today, we're focusing on making sure that we all understand that the rule has been blocked and what that means, and how we should advise community members about public charge given this new turn of events. Next slide, please. So here's the update. As of today, the proposed new public charge rule is still not in effect for people who apply to become legal, lawful permanent residents from inside the United States. Federal judges blocked the new public charge rule from going into effect across the entire country. So the rule did not start on October 15th, and it won't start until federal judges or possibly the U.S. Supreme Court says that the rule can go into effect. So the public charge rule that is blocked is the public charge rule that applies to people who are already inside the U.S. who don't need to leave in order to adjust their status to become a lawful permanent resident. For people who need to go through consular processing to get, for example, to get permission to enter, or people who have to leave the U.S. and then seek permission to return from outside the United States, a different rule applies to them, and that rule has not been blocked yet. So if someone needs to go through consular processing to get their lawful permanent resident status or to enter, or frankly, if someone is preparing to sponsor a family member to come to the U.S. sometime soon, maybe in the next year or so, it would be good to advise those people to seek advice from an immigration attorney and get individualized advice. Next slide, please. So now we all know that the proposed expanded public charge test has been blocked from going into effect. Let's talk a little bit about how that happened. First of all, many people and organizations, and by many I mean over 250,000 people and organizations, sent in public comments to the federal government saying the proposed rule is a terrible idea, that they didn't follow the rules, and that what the federal government was proposing to do isn't legal. Then, when the government didn't listen to those comments and did in fact try to make the rule a final rule, many states and organizations filed lawsuits challenging all the changes the federal government was trying to make to the public charge rule. In all, so far 9 lawsuits have been filed against the new public charge rule. So in those lawsuits, 3 federal judges blocked the new rule from going into effect anywhere in the United States. 2 other federal judges blocked the new rule from going into effect in specific states. Oregon is one of the states that's protected by a state-specific injunction. So really, one way to look at this is that Oregon is doubly protected. Oregon's protected by all 3 of those national injunctions and by the one that applies specifically to Oregon. So in legal terms, what the judges issued is called an injunction. In simpler terms, it means that the judges in the cases that have been filed said that the rule is not allowed to go into effect until the cases get to go to court, have a full trial, and the judges have time to decide whether the new public charge rule is legal or not. Next slide, please. So let's talk more about what does it mean that the rule is blocked. The federal government, the Federal Department of Homeland Security is not allowed to apply the new public charge rule to anyone in the United States. The public charge rule that has been around for a very long time is still in effect. The old public charge rule is in effect because the new public charge rule has been blocked from going into effect. And as a reminder, the old public charge rule is very limited. We are encouraging everyone to really understand the limitations of the old public charge rule and make sure that you are able to help people fight fear with facts. Next slide, please. So while the new public charge rule is blocked, the old public charge rule is in effect. It still applies. So under the old public charge rule, the definition of a public charge is still an immigrant who is likely to become primarily dependent on the government for subsistence. So that really means a public charge, under the rule right now, is someone whose public benefits are the main or the only source of cash in their life, or the only way that they can live in an institution like a nursing home. Next slide, please. So because the new rule is blocked, right now only the old public charge benefits are considered in the public charge test. The old list of benefits is shown here on the slide. These are the only 3 benefits that count against people in a public charge test right now. It's limited to 3 very specific benefits: TANF, temporary assistance to needy families; SSI, supplemental security income; or long-term care paid for by Medicaid in an institution. That's it. Anything that is not on this list is not a public charge benefit under the rules right now. So SNAP is not a public charge benefit. Oregon Health Plan is not a public charge benefit. No housing assistance is considered a public benefit for public charge purposes under the current rule. What else isn't covered? Again, anything not listed here is not a public charge benefit under the rule in effect right now. So WIC is not a public charge benefit. Food banks, food boxes don't count. No health care of any kind counts against you as a public charge, public benefit. Cover All Kids does not count. Emergency medical COWM does not count. Next slide, please. And because the new public charge rule is blocked, the old public charge test still applies. So the government can't use the expanded new public charge test. It can only use the old public charge test. The old public charge test is still a totality of the circumstances test that allows the government to consider a lot of things about a person's life, but they are not allowed to consider public benefits other than those 3 on the last slide: TANF, SSI, and long-term care paid by Medicaid. They're also not allowed to give heavy negative weight to things that they created in the new public charge rule, like low income being at 125% of federal poverty level or below. They were also proposing to give heavily negative weight to people who have, for example, health problems, and they don't have insurance that will cover all their health problems. all of those extra things they added to the test in the new rule are not in effect right now. Next slide, please. So it's really important to remember that the public charge rule, the old rule or the new rule, does not apply to every immigrant. There are lots of exemptions and exceptions. And this list of exemptions and exceptions are the same for the current public charge rule, which is the old rule, and they will still be the same for the new public charge rule if the new public charge rule ever does go into effect. Let's go through this list. Refugees and asylees are exempt from facing the public charge rule. Survivors of trafficking, violence, or other serious crimes like T and U visa applicants or holders do not face a public charge test. VAWA self-petitioners, certain people paroled into the U.S., special immigrant juveniles, people who are already lawful permanent residents or green card holders who don't leave the U.S. for more than 180 consecutive days do not face the public charge test. LPRs who are applying for U.S. citizenship do not face the public charge test. LPRs who need to renew their green card do not ever face the public charge test. And there are more examples, but this is a good list to keep in mind as you're helping advise your community. Next slide, please. Really, most immigrants don't qualify to get public charge benefits unless they are in a category of immigrants who are exempt from the public charge test. Understanding this might help clarify the public charge situation. Although many people will eventually face a public charge test, so for non-exempt immigrants, if you are here, you have a legal path to become a lawful permanent resident. Part of becoming an LPR means facing a public charge test. However, very, very few of those people who are going to have to face a public charge test actually qualify for the benefits that could count against them in a public charge test. Next slide, please. So here are the key facts about public charge in plain language. These are the things we would like you to remember about public charge and help be able to communicate to your clients and the community. The new public charge rule is not in effect yet. The public charge rule does not apply to every immigrant. Many public benefits don't count towards public charge. Public benefits your children or other family members get don't count against you in your public charge test. Just getting public benefits alone cannot make you a public charge. And we encourage everyone to stay informed. Things could change. The resource page that Denise highlighted at the beginning of this presentation, it lists a lot of places where you can keep up to date on any changes to the rule or public charge in general. We're also reminding people that they are not alone. There is help. The public benefits hotline is available for people who have questions. There's a list of immigration attorneys at the at Oregon Ready's immigrationresource.org website, and we really encourage you to send people for good legal advice if they feel like they need that. Next slide, please. We're also encouraging people to go to the Oregon Immigration Resource website and get this fact sheet. The fact sheet is Know the Facts About Public Charge. It's a good reminder of the plain language message, and it has a short list of the immigrants who don't have to face public charge tests and a short list of benefits that don't implicate public charge if someone is facing a public charge test. So please don't forget to get the fact sheets and hand them out to your clients. One thing to keep in mind is the fact sheet is available in English and in Spanish, and is now newly available it's available in several other languages. I think up to 5 or 6 other languages. So please take advantage of this and hand it out to people so that they can get the facts and make good decisions for themselves. Next slide, please. Now we're going to we're going to start talking about some frequently asked questions, some questions that came up after the last webinar pretty commonly. So we'll go through some of these before we go into a live question and answer session. So first frequently asked question is, how long will the public charge rule be blocked? There is no exact date when the block ends, so we all need to stay informed and again use the resources available. They're highlighted on this slide to make sure that you're staying up to date about the public charge issue. It could be a long time before the lawsuits get to have a full trial and the judges get to make a final decision about whether the government is allowed to put the new public charge rules into effect. But honestly, we don't know. We're hopeful that the rule will be blocked for a long time, but it's important to stay tuned and stay up to date. And as I mentioned, feel free to use the resources that are listed here to help you stay up to date. Next slide, please. Next frequently asked question, if the rule is unblocked by a judge, will the rule be retroactive? No. The new public charge rule was blocked before it went into effect. So benefits other than those 3 listed in the current rule, the TANF, SSI, or long-term care in an institution, will not count against immigrants unless the rule is unblocked, actually goes into effect, and then those benefits are received. Next slide, please. Next question, should my clients get off benefits now just in case the rule is unblocked? To this question, we would say that there is not one right answer for everyone, but we would encourage everyone to remind people that many immigrants are exempt from public charge and that there are a lot of benefits that don't count in a public charge test, and the new rule isn't even in effect yet. We would encourage you to provide fact sheets and resources so people can stay updated and so that they can make a good decision for themselves. If clients take a look at the list of immigrants who are exempt from the public charge test and they're in a category on that list, then that client does not need to worry about public charge. If they are not exempt, they're not in an exempt category, but they're getting benefits other than SSI, TANF, or long-term care in an institution, then they're not getting any public charge benefits, so they don't need to get off benefits out of fear of a public charge test. Next slide, please. Next question, I'm a refugee. Should I stop getting benefits until I get my green card so I'm not found to be a public charge? No, refugees are exempt from the public charge in the old rule and in the proposed new rule. So remember, many immigrants are exempt from the public charge rule. A lot of those immigrants they're not aware that they're exempt. People who are refugees are either not signing up for benefits or are disenrolling from benefits right now because they don't understand this. So it would be really helpful to try to communicate that. Next slide. I will be applying for my green card soon. Should my U.S. citizen kids stop getting benefits so I'm not a public charge? The answer is no. Benefits that an immigrant's citizen children get do not count against the immigrant in his or her public charge test. Next slide. My kids get Cover-All Kids Oregon Health Plan. Will this make them a public charge? The answer is no. Cover-All Kids Oregon Health Plan coverage does not count as a public charge benefit under the old rule, the one that's currently in effect, or the proposed new rule. In fact, no OHP program for children counts as a public charge rule either under the current rule or the new rule. Next slide, please. Next question is, I need to renew my green card. Will I face the public charge test? No, the public charge test does not apply when someone is renewing their green card. Next question. I'm already an LPR. Will I face the public charge test when I apply to become a U.S. citizen? The answer is no. The public charge test does not apply when someone is naturalizing to become a U.S. citizen. This naturalization process is statutory. It's based on laws that were passed by Congress. The public charge rule doesn't apply to the naturalization process. Changes to the public charge rule can't change that statute, so the newer rules will have no effect on naturalizing, even if the new public charge rule eventually goes into effect. So now we have time for some live Q&A. Hopefully you've been typing questions in on the platform, and Josie will now ask some of them.
Yeah, so please keep typing questions in. So far we've only had 3. So again, please type questions in as those come up. So the first question is, the list of exempt immigrants, is that the same under the old and proposed new public charge rule?
That's a great question. The list of immigrants who are exempt is exactly the same under the old public charge rule and the proposed new public charge rule that isn't in effect yet. So yes, it is the same list.
Great. Next question. Would a person with refugee status who's petitioning for a family member still overseas through family reunification be impacted or potentially lose their ability to petition for that family member?
Also a good question. This webinar and this public charge discussion is we're not giving advice about what impact benefits can have on people who are sponsoring family members. So that is outside the scope of this discussion, and that is a situation where we would advise someone to speak to their immigration attorney. So we would advise that the refugee get in contact with the immigration attorney to ask that specific question. To be honest, it's not a public charge. It's not a strict public charge question, but lots of the same issues will impact refugees. The most important issue may be their income and other factors, but that's a situation where this basic advice on public charge is not enough, and that person needs to consult an immigration attorney to answer that question.
Thank you. Next question. How about those who are applying for asylum?
People who have asylum status, I'm assuming that the question is, are they exempt from the public charge test? People who have asylum status are exempt from the public charge test. But that is not, so I would say that the advice that we're giving and all the information we're providing applies. The exemption will apply once someone is approved as an asylee.
And then, do both the new and the old rule exempt anyone under age 21?
I'm sorry, can you repeat that?
Sure. Do both the old and new rule exempt anyone that's under the age of 21?
Both the old rule and the proposed new rule that's not in effect yet exempt anyone under the age of 21 who receives health benefits from the public charge test. They're not exempt from the public. I'm sorry. Let me say that more clearly. People under the age of 21 who will face a public charge test will not have any medical benefits that they received when they were under the age of 21 count against them as a public charge benefit when or if they face the public charge test. I hope that was answering the question. And also, I need to go back to the last question. Okay, so I am lucky to have a former immigration attorney sitting next to me. I'm going to go back and revise what I said about asylees. So people who have officially applied for asylum don't face the public charge rule. So if they're in the status of someone who's an asylee applicant, that is enough to trigger the exemption from public charge.
Thank you. Next question, what about H-1B, F-1 visas and renewal extensions?
So the current public charge rule does not apply to any visa extensions. The proposed new public charge rule would extend the reach of the public charge test to include people who need renewals or certain visas, and that is not in effect yet.
Great, thank you. Next question is, how can we access the fact sheets that are available in other languages?
They are available at the OregonImmigrationResource.org website. So if you click on that link, you should get there to their public charge page, and they have a whole list of links for the fact sheet in various languages.
Great. If a U.S. citizen is helping to sponsor a spouse, should the U.S. citizen's spouse and child stop getting any health benefits?
So again, I'll say that the public charge information that we're talking about today and that we talked about on October 8th is really advice for people who are in the United States, who are adjusting to become a legal, lawful permanent resident from inside the United States. And it doesn't necessarily address sponsorship issues. Sponsorship doesn't trigger the same exact public charge questions. There's slightly different analysis to be applied, and sponsorship questions really need to be directed to an immigration attorney. For the most part, I think the greatest worry in a sponsorship situation is going to be a family's income in general, but each case it's a very individualized assessment for sponsorship. So someone really needs to contact one of the attorneys on the immigration attorney resource list at Oregon Ready's website and get some individual advice.
Okay, this next question, if a minor is undergoing the public charge test, but they're not counting their health benefits, does that count against the parents of the minor who might be facing the public charge test as well?
The public charge rule does not implicate, children's benefits that a child receives do not make the parent a public charge. So if the child received, well, first of all, if a child is receiving health benefits, that means that doesn't count against the child in a public charge test. And those benefits also don't count as a public charge benefit. No benefits that the child gets counts against the parent in the parent's public charge test. I will say that under the old and the new, especially the proposed new public charge test that's not in effect yet, a family's income is probably the more important issue than whether they get public benefits or not. So there are issues to decide there, even about getting public benefits. If getting public benefits is making a family more stable and more healthy and maybe able to get a better job or get some education to get a better job, that actually might be the better choice for a family in the long run. But again, that's an individualized decision to make. In general, no benefits that a child receives are going to count against the parent in the parent's public charge test.
So for one of the frequently asked questions that was referenced in the presentation, Senator Nod, should clients get off benefits now in case the rule becomes unblocked? The answer was a bit vague. Could you expand?
Well, so I guess what I would say is that right now people can know that SSI, TANF, and long-term care in an institution are the three benefits that will count that can count against someone in a public charge test. The list of benefits that the proposed new rule that's blocked proposed to add to that list of public benefits that can count against people in a public charge test. Our advice would be that don't worry about getting that expanded list of benefits. So that expanded list included SNAP and housing assistance and Oregon Health Plan for non-pregnant adults and a few other things. So our advice would be do not worry about that expanded list of benefits, because that expanded list of benefits, those benefits don't count against anyone in a public charge test until that rule goes into effect. So there's no benefit to getting off of those public benefits before the rule goes into effect.
So this person is a bit confused about the difference between public charge and the public charge test. Are they the same thing, or what exactly is the test?
That's a good question. These are hard concepts to describe and very hard concepts to understand. So an immigrant can be denied the right to come to the U.S. or to stay in the United States if they're determined to be a public charge. And in order for the government to determine whether someone is a public charge or not, they apply this test, the public charge test. So the public charge test is the questions that are asked and the evaluation that happens so that the Federal Department of Homeland Security can make the decision about whether they think someone is a public charge or really is likely to be a public charge in the future. I would recommend going back to the October 8th webinar and going over the slides. Really, that webinar really kind of goes through the concepts in sort of an order that may help make this make more sense. But in general, the public charge test is the evaluation that the feds use, the federal government uses, to determine if they think someone is a public charge or not.
Could you please repeat the extra answer regarding those applying for asylee status? So applied for but have not yet received asylum.
So I think I will say that it's a complicated question, and anyone who is in the process of applying for asylum status should contact their immigration attorney and get a very clear idea of where they are in the process and use that answer to determine whether they are exempt from public charge or not.
What should we do if we hear of immigration attorneys potentially providing bad legal counsel about public charge?
That's a great question. I think first I would say that these issues are incredibly complicated, and there may be factors in a particular immigrant situation that makes the advice makes our general advice about public charge not apply to them. So for example, if somebody really was, maybe they're exempt from public charge, but they have another situation in their family, maybe potential sponsorship of a family member that's triggering some different advice from an immigration attorney. So first of all, it's hard to know when someone is getting good or bad advice. But I would say that if someone feels like the public charge information on our fact sheets and through these webinars does apply to them, and they are not getting that advice from their immigration attorney, it might be helpful to give that client factual information and maybe advise that they print out the fact sheet and bring that to their immigration attorney and ask the immigration attorney to really explain why the public charge advice that we are giving, or that they understand to be true, doesn't apply to them. And that will help them either understand the nuance of why there's something different about their situation that makes this public charge advice not applicable to them, or help the immigration attorney understand that they do in fact fall into a category of people who maybe do not have to worry about public charge. And I also might advise that if a client was coming to me with that question, I might advise that they really make it clear to their immigration attorney why the public benefits that their family receives are important to them. It may not be on the top of all attorneys' minds why why it would be so important to get some nutrition assistance for a family or to get health care benefits, for example.
Will there be notice ahead of time if the new rule is unblocked?
So what we expect, it's hard to know for sure, but what we expect is that if the rule becomes unblocked, first of all, it will depend on what the judges order. But if the block just went away, what is most likely to happen is that the rule would go into effect on the day the block is lifted. In the proposed new rule, the rule itself stated that the benefits would not, the rule would not be implemented, the benefits would not count against people until 60 days after the rule went into effect. So we anticipate that there will still be a buffer of time, even if the rule is unblocked, where people have time to get advice and take some action if they feel like they need to. I can't say that with 100% certainty because we don't know exactly what the end of a lawsuit would look like, but that's the most likely end result if the rule is unblocked.
So this question is kind of a two-parter, but this person previously understood that LPRs or green card holders who are looking to become naturalized citizens would be affected if the new rule goes into effect. Are you saying that an individual who meets SNAP eligibility criteria as an LPR runs no risk in regards to public charge and their naturalization process? So someone that already has a green card and is on SNAP, would that be an impact?
The naturalization process is not impacted by public charge in any way. It's not under the current rules, the rules that have been around for decades, and it is not proposed to be included in the proposed new rules. So the naturalization process the public charge test does not apply to someone in the naturalization process. The only risk to a person, well, for the most part, the only risk to a person who's an LPR already to getting benefits is if they leave the country for more than 180 consecutive days, they need to seek re-entry, and it is possible that the public charge test could be applied to them as they seek re-entry after being gone for more than 6 consecutive months. So other than that, the naturalization process is a federal statutory process that does not include public charge tests, so the public charge test cannot apply in the naturalization process.
Okay. If a person has LPR status, they wouldn't technically qualify for SSI until after a 5-year waiting period. Does that sound correct?
Correct.
So after that 5-year waiting period, and they now qualify for SSI, how would that impact them from a public charge perspective?
Well, if they are already an LPR and they're not planning on leaving, and they don't leave the United States for more than 180 days, then they won't be facing a public charge test. I think there are some possible times when somebody would, but they have to do it like if their LPR status was threatened because they were convicted of a crime or something like that. But in general, people who are LPRs who don't leave the country for more than 180 consecutive days are not going to face a public charge test.
Okay, and related to that question, then for someone that is in that 5-year waiting period, they're not yet on SSI, how would public charge impact someone like that?
Again, someone who already has their LPR status, they already have their green card, they are not going to face a public charge test unless they leave the country for 180 days and then seek 180 consecutive days and then seek re-entry. I think maybe what the questioner is getting at, that person who is an LPR who hasn't been an LPR for 5 years yet also doesn't qualify for any of the benefits that could trigger a public charge test, even if they were to face one. But LPRs don't face public charge tests unless they leave the U.S. for more than 180 consecutive days and seek re-entry.
Can unpaid medical bills potentially impact someone's public charge test?
That's a difficult question to answer. The public charge test currently is a totality of the circumstances test, and the immigration officials are allowed to consider someone's financial circumstances. It has not been traditional for people to have their consumer status examined under the old public charge rule, which is in effect now. The proposed new public charge rule that is not in effect yet, the one that's blocked, is proposing to include in the public charge test a review of people's credit score and consumer history. So if the new rule goes into effect, that might be factored in. I can't say for sure that it wouldn't be even considered in the current public charge test, but it certainly wouldn't have the same weight that it would under the proposed new rule.
So for people who are in the process of becoming a lawful permanent resident and they're almost complete with the process, say the new public charge rule does become unblocked and goes into effect, how would it impact them at that point? Would the old rule apply to them, or would the new rule apply to them?
The people who have already applied, people who apply to become a lawful permanent resident, even who have mailed the application before the effective date of the new rule, and we don't know what the effective date of the new rule is because it's blocked right now, are evaluated under the old public charge rules. So right now, everybody who is applying to be an LPR who's already in the process, the old rules will continue to apply to their case.
So the next question is in regards to TANF. So for TANF, the non-citizen parent is not in the benefit group. So technically the parent is not receiving TANF benefits in this scenario, only the children. Are those parents going to face a public charge test question? And then if not, then who might face a public charge test for those receiving TANF?
So that's a question that really depends 100% on what the immigration status is of the people in the family. If the family members are in a status that where they have a clear path to becoming a lawful permanent resident, then they may face a public charge test. If family members do not have a clear path right now to become an LPR, then they are not likely to face a public charge test. So I guess I can't answer the question without knowing the specifics of what the status is of the people who are in the family. However, children wouldn't be receiving TANF if they didn't have immigration status that doesn't require a public charge test. In general, people who, benefits that children are receiving are not counting against parents if they do, are in a category of people who do face a public charge test in the future.
Will elderly people that do not have citizenship fall under the public charge rule if they receive public or subsidized housing?
Well, remember that the only people who ever face a public charge test are people who are in the process of either entering the United States or are in the United States and are adjusting their status to become a lawful permanent resident or get their green card. So an elderly person who is in the process of becoming a lawful permanent resident will face the public charge test. Right now, under the old rule, housing assistance does not count as a public benefit that counts against you in the public charge test. If the proposed new rule is unblocked and eventually goes into effect, certain types of housing assistance are proposed to count against immigrants in their public charge test. So Section 8 and public housing are proposed to count against people in the public charge test. Right now they don't. Under the old rule they don't. Under the new rule, if it ever becomes unblocked, they do. Other types of housing subsidies that aren't Section 8 based or public housing based are not slated to count against people in a public charge test. So our advice would be for people to probably reach out to their housing authorities. For example, people might be living in a low-income housing tax credit property, and if that person is getting a reduced rent because they live in a low-income housing tax credit property, that won't count against people in a public charge test, even if the new rule goes into effect. It doesn't count now because there's no housing benefits included in that list of 3 public charge benefits. Under the new rule, some housing benefits, Section 8 and public housing, will count, but some housing benefits won't. So we would advise people to reach out to their housing provider to really confirm what subsidies people are getting. And if it's not a Section 8 voucher or a project-based Section 8 voucher or public housing, then the benefits that they get won't count against them in a public charge query.
So for someone who is in the LPR process, or in their process of applying for their green card, and they received TANF for only 1 month in the past, could that affect them?
It is unlikely that would have very much of an effect in a public charge test. But under the current rules, that is, receipt of TANF, SSI, or long-term care paid for by Medicaid do count in a public charge test. But remember, the current definition of a public charge is someone who is, let's see if we take a look back at the previous slide. The current public charge definition is someone who is likely to become primarily dependent on the government for subsistence. So 1 month of TANF does not indicate that their main source of income and the only way they can really survive is by existing off of the cash they get from TANF. So it's unlikely that it would have much of an effect. And remember, people who are, if you can qualify to get TANF, they likely have an immigration status that makes them exempt from the public charge test.
So this will be the last question we take. It's also regarding the test. How is it administered exactly? Is it online, or is someone sitting with the applicant and helping them complete it, or how does that work?
Well, that's an excellent question. In general, right now, it's generally in an interview. There's usually an interview with, you're asked to gather documentation ahead of time to prove what you have and haven't gotten, to be able to talk about your income, etc. So the new rule that's not in effect yet has also proposed with it a new form that people will have to fill out if the rule is unblocked, to really get at all the things they've applied for, etc. But that's not in effect yet. So right now it's more of an interview process, but people do need to gather documentation to sort of be able to support what they're asserting in their public charge test.
Great. Thank you. And then we did receive a few questions about where folks can go to access the October 8th webinar that we did on public charge for Oregon service providers. So that can be downloaded, both the recording and the slides, from the OregonImmigrationResource.org website. And it's also available for download on the Oregon Health Authority's public charge webpage dedicated, again, to public charge. And links to those websites are included in this slide deck, which we hope to get out to folks by mid next week. So keep an eye out for an email with these slides and the recording of today's webinar.
And so thank you all for joining us for this webinar today. If you have any questions that weren't answered, please feel free to contact our presenters. And with that, enjoy the rest of your day. Thank you.